We now come to the 10-minute rule bill. Rob Butler.
Mr. Speaker, I beg to move that leave be given to bring in a bill to provide that persons charged with a criminal offence having been aged under 18 at the time of the alleged offence are subject to the jurisdiction of the Youth Court and to youth sentencing provisions and for connected purposes. Mr. Speaker, at the outset I should declare that prior to my election I was a magistrate in both adult and youth courts, a member of the Youth Justice Board, non-executive director of Her Majesty's Prison and Probation Service and a member of the Sentencing Council. Mr. Speaker, justice delayed is justice denied. I submit this is even more starkly so in the case of child offenders. The UN Committee on the Rights of the Child states, child justice systems should also extend protection to children who are below the age of 18 at the time of the commission of the offence, but who turn 18 during the trial or sentencing process. My bill seeks to ensure that becomes the case in England and Wales. At the moment, the justice system treats a defendant according to their age on the date they first appear in court and enter a plea. The consequence of this is that if someone commits an offence aged 15, 16 or 17, but don't get to court until after their 18th birthday, they're treated as an adult. This immediately affects both the type of court that deals with them and the range of sentences available. But the repercussions don't stop there, because there can be an impact on the chance of rehabilitation, the likelihood of getting a job, the prospect of forever having to declare a mistake from the past. It is no exaggeration to say that the consequences can last a lifetime, because in our justice system on your 18th birthday there is a cliff edge, and it is a very steep cliff. Mr. Speaker, a child defendant under the age of 18 in England and Wales will appear before a youth court, which has specially trained magistrates and judges. They know how to interpret a young person's behaviour, and they speak directly to the children in front of them, asking them why they committed the offence and ensuring they understand its consequences. Children appearing in the youth court are supported by the Youth Offending Service, expert multidisciplinary teams based in local authorities. Perhaps most significantly, in the youth court, young people can be sentenced to a referral order, which focuses on rehabilitation and restorative justice, and is overseen by the Youth Offending team. Once the referral order is completed, the offence is immediately spent, meaning the young person does not carry a criminal record. These procedures exist because the youth justice system has an overarching aim set down in legislation to prevent reoffending, and courts must therefore make that their priority. It should go without saying that reducing reoffending means there will be far fewer victims of crime, and that must surely be welcomed by all. Mr. Speaker, all this changes if a young person turns 18, even a day before their case gets to court. There's no special training for the judiciary, no dedicated support from the Youth Offending Service, no bespoke sentence, and no priority on reducing reoffending. What's more, as an adult, harsher criminal record and disclosure requirements further decrease employment prospects and risk preventing people moving on with their lives. And yet this is something over which the young person has absolutely no control. The main reason that children turn 18 before going to court is because of a delay in the system, either the police investigation or the court listing process. Whether a particular individual youth suffers a delay is a matter of chance. Indeed, our current system means there is a postcode lottery as to whether someone is treated as a child or an adult, as different police forces and different courts can take widely varying times investigating or listing cases. So two 17-year-olds with exactly the same birthday could commit exactly the same crime on exactly the same day in different parts of the country, but find themselves treated entirely differently according to how quickly their case comes to court. Mr. Speaker, there seems neither logic, nor common sense, nor fairness in that. And Mr. Speaker, the problem is significant. The Youth Justice Legal Centre says approximately 20% of all the calls to its helpline are about delays to cases where young people are turning 18. And while there are no precise official figures as to how many young people are caught in this trap, it has previously been suggested that 2 to 3% of proven offences are committed by children who turn 18 before their conviction. Now that translated to 1,400 for the year ending March 2018, and the problem has been exacerbated more recently, both by changes in police procedure and by the coronavirus pandemic. First, the growing use by police of release under investigation has resulted in delays to charging decisions, with the average number of days between an offence and the charge for youth cases increasing by 78% in the past 9 years. There's also been an increase in the delay from charge to the first court listing by a further 61%. Indeed, it can easily take a year before the first court appearance, and even longer in the case of some serious offences. Second, COVID-19 has lengthened delays throughout the whole court system. There's consequently a particularly worrying impact on the increasing number of young people who will have their 18th birthday before their first court appearance. The Justice Select Committee, of which I'm a member, highlighted this in our recent report on the impact of COVID on the courts. So the changes proposed in my bill are needed, and they are needed now. Mr. Speaker, some people may ask why we should care when we are, after all, talking about criminals. Well, what is crucially important is the fact that people do not magically become an adult at the stroke of midnight on their 18th birthday. Indeed, it is now widely acknowledged and accepted, including by the Ministry of Justice, that young people's neurological development continues well into their 20s. Importantly, this has a substantial impact on behaviours linked to offending, such as impulse control, empathy, and understanding the implications of actions. The Code for Crown Prosecutors already recognises this, and the National Police Chiefs Council's Lead for Children and Young People has emphasised the importance of diversionary and preventative measures. This entirely chimes with the approach taken by the Youth Court and by youth offending teams, but not by the adult justice system. Mr. Speaker, the justice system needs to tackle offending behaviour according to a person's culpability, maturity and potential for rehabilitation. That is why we should care. And there is precedent for criminal justice consequences to flow from the date an offence is committed. Examples include the sentence of detention at Her Majesty's pleasure and certain mandatory minimum sentences in the Firearms Act and the Violent Crime Reduction Act. What's more, and perhaps rather ironically, the victim surcharge on an offender is applied according to the age at which they committed the offence, not the age at which they're sentenced or first appeared in court. I should very briefly just set out examples of what this bill would not mean. It would not mean that somebody who was 18 or over when sentenced would go to a custodial establishment for under 18s. Indeed, it's already the case that a young person serving a custodial sentence will be transferred to the adult estate on or soon after their 18th birthday. And it would not mean that someone who committed a crime at 17 but was only identified as the perpetrator when they were very much older, say at 30, would physically attend the youth court. There would be an upper age limit in the early 20s. Mr. Speaker, there is a very strong consensus in favour of the changes I propose today. On the front line, the Association of Youth Offending Team Managers wants to see exactly these measures introduced. The Magistrates Association last year passed a motion in support of keeping such cases in the Youth Court with 96% in favour. The Alliance for Youth Justice, which brings together more than 70 organisations, believes the measures in this bill would allow for fairer, more equitable and age-appropriate justice. The bill is supported by T2A, Transition to Adulthood. My proposals are also endorsed by academic and legal experts, including the National Association for Youth Justice, Just for Kids Law and the Youth Justice Legal Centre. The Justice Select Committee has called for these changes, and the Youth Justice Board itself backs these measures. The YJB's chair, Keith Fraser, is a former police superintendent who was himself assaulted by a teenager when he was a serving officer. But he believes it is wrong that someone who commits an offence as a child then gets treated as an adult by the system. The Children's Commissioner wants to see these changes, and finally, Mr. Speaker, my bill has cross-party support in this House, for which I'm very grateful. If my bill succeeds, Mr. Speaker, a young person who commits an offence before their 18th birthday will be subject to the Youth Court and to youth sentencing provisions. This would be a relatively simple change to make in legislation. In many respects, it does no more than correct an anomaly. But for those affected, its impact would be profound. It would enable young people to put their mistakes behind them and make a constructive contribution to society. It would put more emphasis on preventing reoffending. It would mean a fairer system. Mr. Speaker, it would mean a more just system.
That the honourable member have leave to bring in the bill. The question is that the honourable member have leave to bring in the bill. As many of that opinion say aye. Aye. Thank goodness for that. Of the contrary, no. I think the ayes have it, the ayes have it. Who will prepare to bring in the bill?
Mr. Speaker, Sir Robert Neal, Maria Eagle, Jeremy Wright, Edward Timpson, Andrew Selous, Crispin Blunt, Dan Jarvis, Sarah Champion, Danny Kruger, Sally Ann Hart, and myself, Mr. Speaker.
Rob Butler.
Youth Courts and Sentencing Bill.
Second reading what day?
Tomorrow.
Tomorrow. Hold on.